जय हिंद दोस्तों, फिर से आपका स्वागत है हमारे इस वाजीराम रवि के प्रीलिम्स की रिवीजन सीरीज़ में, जो कि 2024 के लिए निकाला हुआ या पार्ट 1 है। मई 2023 से लेकर दिसंबर 2023 तक का, और पार्ट 2 आने वाला है इसका जल्दी, और तब तक हम लोग यह पूरा बुक समाप्त कर लेंगे। तो आप लोगों को जैसे पता ही है, डेट 26 मई 2024 है प्रीलिम्स का। तो आप लोग उसके लिए लगे होंगे, और हम भी आपका साथ देने के लिए यह सीरीज़ शुरू कर रहे हैं। तो अगर आप लोगों ने पहले की वीडियोज़ नहीं देखे हैं तो आप इस प्लेलिस्ट में इसका लिंक दिया हुआ है, जाइए आप इसके प्लेलिस्ट में देखिए, डिस्क्रिप्शन में लिंक है। और आपसे बस ये अनुरोध है कि आप अगर हमारे चैनल पर नए हैं और अभी तक हमारे चैनल को सब्सक्राइब नहीं किया तो प्लीज़ 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 इसे सब्सक्राइब करके हमें सपोर्ट करें, और ज़्यादा से ज़्यादा बार रिवाइज करें, ताकि आपका रिवीजन अच्छे से हो सके और आप लोग एग्जाम में अच्छा परफॉर्म कर सकें। अगर आपके नज़र में कोई और आपके दोस्त, फ्रेंड, मित्र या कोई भी हैं जो इस बार प्रीलिम्स देने वाले हैं, तो उन तक इस वीडियो को जरूर पहुँचाएं, ताकि वो भी इससे लाभान्वित हो सके और अपनी तैयारी को और मजबूत कर सके। आज हमारा शुरू होने वाला यहाँ से टॉपिक रजिस्ट्रेशन ऑफ बर्थ एंड डेथ अमेंडमेंट एक्ट 2023। यह बाइलिंगुअल होने वाला है, तो आप लोग बिल्कुल भी टेंशन नहीं लें, आराम से बस वीडियो को सुनते रहें और रिवीजन करते रहें। आइए शुरू करते हैं। बस शुरू करने से पहले फिर से ये अनुरोध रहेगा कि अगर आप लोग हमारे चैनल पर नए हैं और अभी तक हमारे चैनल को सब्सक्राइब नहीं किया तो प्लीज़ 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 इसे सब्सक्राइब करके हमें सपोर्ट करें। आइए शुरू करते हैं। रजिस्ट्रेशन ऑफ बर्थ एंड डेथ अमेंडमेंट एक्ट 2023 की फीचर्स ऑफ द एक्ट क्या क्या है देख लेते हैं। द एक्ट गिव्स द रजिस्ट्रार जनरल ऑफ इंडिया द पावर टू मैनेज a national birth and death registry, while chief registrar maintain comparable databases at the state level. Chief registrar appointed by a state and registrar appointed by a state for local areas will be required to contribute data to this national database. The act provides digital registration and electronic delivery of certificates of birth and death. The act requires certain person to report birth and death to the registrar. For example, the medical officer in charge of a hospital where a baby is born must report the birth. The act permits the Registrar General of India to share the birth and death database with agencies in charge of maintaining other databases such as voters' rolls, population register, Aadhaar number, etc. The act requires the use of birth and death certificate to prove the data and place of birth for persons born on or after the act comes into effect. This information will be used for purposes including admission to an educational institution, preparation of voters list, appointment to the government post, and any other purpose determined by the central government. It will be compulsory for a state to register birth and death of the Central Civil Registrar System (CRS) portal and share data with the RGI. The Registrar General of India comes with the ambit of Ministry of Home Affairs. अगला टॉपिक है सेडिशन। सेक्शन 124A of Indian Penal Code penalize a crime against the state. Sedition refers to any act of attempt to bring hatred or contempt towards the government established by law in India, or to incite dissatisfaction or resistance against it. Punishment under 124A. Sedition is a non-bailable offence. A person charged under this law cannot apply for government job. They have to live without the passport. Upon conviction, the person can be punished with either life imprisonment and a fine, or imprisonment for up to 3 years and a fine of, or just a fine. Supreme Court on Sedition Law. In 1962, the Supreme Court in Kedarnath Singh versus State of Bihar upheld the constitutional validity of IPC Section 124A. However, the court attempted to restrict its scope for misuse. The court held that unless accompanied by an incitement or call for violence, criticism of the government cannot be labeled sedition. In Balwant Singh versus State of Punjab 1995 case, Supreme Court held that merely shouting slogan, in this case Khalistan Jindabad, does not amount to sedition. Recent update क्या है, तो the 22nd Law Commission has urged the sedition law need to be retained by certain amendments should be made for greater clarity regarding its urge. It has recommended to include the ratio of the Kedarnath ruling in the sedition law provision. Section 126 of Indian Evidence Act about it deals with the burden of proof in case where a fact is within the special knowledge of a person, and states that when any fact is within the knowledge of any person, the burden of providing the fact is upon that person. Example में क्या है, तो imagine a situation where an opposition political party alleged widespread election fraud during a recent election and claimed to have evidence of such fraud. In this case, Section 126 can be applied. The burden of proving election fraud rests with the opposition party, as they are the one making the claim. Since they have evidence of fraud, they have a responsibility to present that evidence to substantiate the allegation. It applies to civil and criminal cases alike and laws down an important principle of evidence. The burden of proof under Section 106 is not absolute, and the person who has special knowledge of the fact is only required to prove it to the extent that is responsible in the circumstances. The person is not required to prove the fact beyond any doubt, but only to the extent that a responsible person would believe it to be true. Suspension of MPs. Recently, the Lok Sabha and Rajya Sabha suspended 141 opposition MPs for disrupting parliamentary proceeding while protesting parliament security breach. By whom? The presiding officer, that is the speaker in the case of Lok Sabha, and the chairman in case of Rajya Sabha play a major role in suspending the MPs following same process. To guarantee the appropriate conduct of proceeding, the speaker या chairman possesses the authority to compel a member to leave the house. Process of suspension क्या है? तो general rule है, the presiding officer can direct the MP to withdraw from the house for any disorderly conduct in accordance with the rule of procedure and conduct of business of Lok Sabha and Rajya Sabha. To deal with more reluctant या uncooperative, if it does not work and the said MP continues to disrupt the house proceeding, the presiding officer can name the legislator, post which the house can move a motion to suspend the MP until the end of the session. Introduction of automatic suspension. ये कब हुआ था? The Lok Sabha further empowered the speaker in 2001 to deal with grave and disorderly conduct under the new rule, which states that MP named by the speaker shall automatically stand suspended for a period of 5 days or the remaining part of the session without any need of the House to pass a motion for suspension. This provision has not been incorporated in the proceeding of Rajya Sabha. This means, unlike Lok Sabha, Rajya Sabha cannot suspend its member without passing a motion for the time. Types of punishment for misconduct. A person found guilty of breach of privilege or contempt of House may be punished in either by imprisonment or by abmotion, a warning, or reprimand. Two other punishment may also be awarded to the members for contempt, namely suspension or expulsion for the House. Difference between exclusion and disqualification. While an expelled member, this result in the MP losing their seats in Parliament, can contest the elections against and get re-elected as an MP in the next term. A disqualified MP cannot do so. While the reasons for an MP's disqualification can include mental unsoundness and getting convicted in a criminal case. Can the courts intervene? Although parliamentary proceedings are protected for judicial scrutiny under Article 122 of the Constitution, courts have at times intervened the procedural function of legislator. Immunity to parliament proceeding. क्या क्या देख लेते हैं? तो आर्टिकल 122 provides immunity to parliamentary proceeding from a challenge in court. It states that validity of any proceeding in parliament cannot be called into question on the ground of any alleged irregularity of procedure. It also provides immunity to any officer or member of parliament in whom power are vested by or under this constitution for regulating procedure or the conduct of business, or for maintaining order in parliament from action in any court with respect to the exercise by whom of this power. MLA faces disqualification after conviction. Recently, the Tamil Nadu Higher Education Minister has convicted a disappropriate asset case under Prevention of Corruption Act (PCA). The MLA now faced the risk of disqualification from the Legislative Assembly. Disqualification of member of Legislative Assembly (MLA). An MLA can be disqualified through Article 191 of the Constitution, Article 102 in case of member of Parliament for holding an office of profit, being of unsound mind or insolvent, or not having valid citizenship, through the 10th schedule of the Constitution, that is under the anti-defection law, if the MP or MLA पहला voluntarily give up his membership for a political party. दूसरा, disobey the direction of his political party or votes or does not vote in the legislature contrary to the direction of his political party. थर्ड है joins another political party after the election. और फोर्थ है join any political party 6 months after becoming an MLA in case of nominated members. Under the following provision of Representation of People Act RPA 1951, तो उसके अंदर क्या है, तो सेक्शन 8 ऑफ द RPA विच डील विद डिस्क्वालिफिकेशन फॉर कन्विक्शन ऑफ ऑफेंस सच एज, क्या क्या है, तो प्रोमोटिंग इमिटी बिटवीन टू ग्रुप्स, barbarely or undue influence or personation at any election, section 8 clause 1, hoarding or profiting adulteration of food or drugs, and for conviction and sentence of at least 6 months for an offense under any provision of the Dowry Prohibition Act, section 8 clause 2. If sentenced to imprisonment for not less than 2 years, section 8 clause 3, he disqualified from the date of such conviction and shall continue to be disqualified for a further period of 6 years since his release. A disqualification takes place only after 3 months from the date of conviction. Within this period of 3 months, the convicted MLA can file an appeal against the conviction in a high court. Section 1 clause 4. This provision was struck down by the Supreme Court in the Lily Thomas versus Union of India 213 case. Section 9 deal with disqualification for dismissal for corruption or disloyalty and for entering government conducts where while being a lawmaker. Section 10 क्या है, तो disqualification for office under government company. Section 11 तो removal or reduction of period of disqualification. Can the disqualification be reversed? A disqualification can be reversed if a high court grants a stay on the conviction or gives a decision in the favor of the convicted MLA. A stay or conviction is important before filing an appeal for preventing disqualification. अगला हमारा हेडिंग है जुडिशरी. तो जुडिशरी के अंदर जितना भी हुआ करंट अफेयर में वो देख लेते हैं. तो उसमें पहला है फोरम शॉपिंग. उसमें देखते हैं तो द चीफ जस्टिस ऑफ इंडिया रिसेंटली डिनाइड परमिशन फॉर फोरम शॉपिंग टू ए litigant appearing before him. Forum shopping is when litigants or lawyers deliberately try to move their case to a particular judge or court expecting that this would turn the judgment into their favor. Types क्या है, तो domestic, when a litigant chooses between two or more courts within a country. Transnational क्या है, तो when a litigant chooses between the court of two or more countries. Global scenario क्या है, the US and UK court have criticized the practice of forum shopping as something to be avoided or prohibited. Indian judicial have condemned this practice and termed it as an abuse of law. Next is arbitration and conciliation. Arbitration and Conciliation Act 1996. The act represented a significant improvement over prior arbitration law in India, including the Arbitration Act of the 1940s, the Arbitration Act of 1937 and the Foreign Award Act of 1961. This legislation covers international commercial arbitration, domestic arbitration, and the informants of foreign attribute arbitral award. It draws inspiration from the model law of the United Nations and allies with the legal framework adopted by United Nations Commission on International Trade Law UNCITRAL. Arbitration and Conciliation Amendment Act 2019. The amendment aims to establish an independent body called the Arbitration Council of India ACI to promote arbitration, mediation, conciliation and other alternative dispute resolution mechanism. Arbitration Council of India ACI. According to the Constitution of India, specifically Article 51, under the directive principle of state policy, India is obliged to encourage the settlement of international disputes through arbitration. The creation of ACI is a step towards fulfilling this constitutional obligation. ACI will be led by a chairperson who must have served as a judge of the Supreme Court, a chief justice or a judge of high court, or an eminent person appointed by central government in consultation with the Chief Justice of India. Additionally, ACI will have two full-time members selected from distinguished arbitration practitioner and academician. डिफरेंस बिटवीन आर्बिट्रेशन एंड कॉन्सलाइजेशन। कॉन्सिलेशन क्या है देख लेते हैं। तो कॉन्सिलेशन इज एन एडवर्सल प्रोसेस दैट एम टू फैसिलिटेट डायलॉग एंड प्रोmote ए म्यूचुअली adoptable resolution between parties. A conciliator is a neutral third party who asserts practices in identifying issues, exploring options, and reaching a settlement without imposing a decision. Conciliation results in a settlement agreement between parties, which is a contract that requires voluntary compliance. If either party fails to fulfill its obligation to other party, may seek remedies through court proceeding. आर्बिट्रेशन में क्या है? तो आर्बिट्रेशन इज एन एडवर्सियल प्रोसेस वेयर पार्टीज प्रेजेंट देयर केस टू आर्बिट्रेट हु मेक ए बाइंडिंग आर्बिट्रल अवार्ड एडवोकेटिंग फॉर ए नॉन इंटरवेंटलिस्ट role by judge to oversee prosecution and prove their case. The arbitrator served as a private judge, interpreting evidence, considering arguments, and delivering an enforceable decision. Arbitrator awards are legally binding decisions that can be enforced in court, with the losing party being required to comply with the terms of the award. नेक्स्ट इज नेशनल जुडिशियल डाटा ग्रिड एंड पोर्टल। कॉन्टेक्स्ट क्या है? तो रियल टाइम डाटा ऑन द फाइलिंग ऑफ डिस्पोजल ऑफ केसेस इन द सुप्रीम कोर्ट विल नाउ बी अवेलेबल थ्रू द नेशनल जुडिशरी डाटा ग्रिड NJDG. द NJDGSCI Supreme Court of India portal will include the following data: the current pending case, civil and criminal cases filed and disposed in the previous month, number of cases pending before 3 judge, 5 judge and even 9 judge benches. About में क्या है तो देख लेते हैं. It is the national data repository aligned with the National Data Sharing and Accessibility Policy NDSAP, created in 2015 under the e-court project, and contain detail of orders, cases, civil and criminal, and judgment of district and subordinate courts, high court, and allow real-time data updation by connected district and taluka court. NJDG was built as part of phase 2 of the e-court project, which is centrally sponsored scheme. Developer the National Informatics Center NIC and Computer Cell, Supreme Court Registry. The NIC was established in 1976 and is under the Ministry of Electronics and Information Technology. Maitri, the NIC provides IT services, infrastructure and consultancy to central and state government. E-court project. नेक्स्ट टॉपिक आवर इज ई कोर्ट प्रोजेक्ट. इसके अंदर देखते हैं अबाउट में क्या है. द ई कोर्ट मिशन मोड प्रोजेक्ट इज अ सेंट्रली स्पॉन्सर्ड स्कीम लॉन्च्ड इन 2006 एंड इज अ पार्ट ऑफ द नेशनल ई गवर्नेंस प्लान, monitored and funded by Department of Judiciary, Ministry of Law and Justice for the district court across the country. Implementation. The Supreme Court is responsible for its policy planning, strategic direction and implementation. Phase 1 में क्या हुआ तो launched in 2007. During this phase, पहला computer server room and judicial service center were prepared for computerization of the district court and district court website were launched. दूसरा, judicial officer and court staff were trained under change management exercises to use computer and case information system CIS. Phase 2 में क्या है तो it is approved in 2015. During this phase, पहला, uncovered court of phase 1 and newly established court were provided with new hardware system per courtroom and LAN connectivity etc. दूसरा, national judicial data grid was launched for providing case details and status online of all the district and high court of India. Phase 3 में तो recently approved and its proposes to पहला, to assure in a regime of maximum ease of justice by moving toward digital, online and paperless courts through digitalization of the entire court records including legacy records. दूसरा है implement a smart scheduling system to recommend an appropriate schedule for listing case based on availability of judges, lawyers, witnesses, nature of the case and case load of the judge. न्याय बंधु प्रोग्राम. तो इस प्रोग्राम के अंदर देखें क्या है. न्याय बंधु प्रोग्राम was launched in 2017 and is being implemented by National Legal Service Authority NALSA. It provides legal aid in a variety of areas including civil, criminal and family law. The program also provides legal aid to people who are facing discrimination or who are being denied their basic rights. It is a mobile application which provides pro bono legal service to the one who are unable to afford legal advice and or cannot accede legal aid. Pro bono is a Latin word which means for the public good. Use this Using this application, practicing lawyers will be able to register themselves and connect with registered beneficiaries, providing them services for free or at a minimal cost and present them with an opportunity to address their legal problem meaningfully. It also provides the feature of tracking case status. It utilizes the scheme optimally. Department of Justice has proposed setting up a pro bono panel of lawyers at each high court. दिशा स्कीम क्या है? तो दिस स्कीम लॉन्च्ड फॉर अ पीरियड ऑफ 5 years 2021 to 2026 to advance the cause of access to justice. It aims to design and consolidate various initiatives to provide citizen-centric delivery of legal services. There are 3 components under दिशा at present. पहला है न्याय बंधु प्रोग्राम, दूसरा है तेली लॉ और तीसरा है लीगल अवेयरनेस प्रोग्राम. यहाँ पर देख लेते हैं अबाउट लीगल सर्विस अथॉरिटी एक्ट 1987. तो इसमें क्या है? It establishes National Legal Service Authority, State Legal Service Authority and District Level Legal Service Authority to पहला provide free and competent legal services to the weaker section of the society और दूसरा it ensures the opportunity to securing justice are not denied to any citizen due to economic or other disabilities. It organizes Lok Adalat to ensure that the operation of the legal system promotes justice on a basis of equal opportunity. सेक्शन 12 क्या है? तो सेक्शन 12 ऑफ द एक्ट स्पेसिफाइज द क्राइटेरिया टू सेलेक्ट द पर्सन इंटाइटल टू रिसीव फ्री लीगल एड एंड सर्विसेज. इट इंक्लूड्स. तो 8 पॉइंट्स है, देख लेते हैं कौन कौन सा है. मेंबर ऑफ शेड्यूल कास्ट एंड शेड्यूल ट्राइब्स, विक्टिम ऑफ ट्रैफिकिंग इन ह्यूमन बीइंग और बेगर एज referred in Article 23 of the Constitution, woman or a child, person with disability, person in custody, an industrial workman, victim of a mass disaster, ethnic violence, caste atrocity, flood, drought, earthquake or industrial disaster, person with annual income less than as specified under the law. Next scheme is special level petition, स्पेशल लीव पिटिशन. तो उसमें देख लेते हैं क्या क्या है पिटिशन में. अबाउट में अंडर आर्टिकल 136 ऑफ कॉन्स्टिट्यूशन द सुप्रीम कोर्ट में इन इट्स डिस्क्रेशन ग्रांट अ स्पेशल लीव टू एन एग्रीवेड पार्टी टू अपील अगेंस्ट एनी जुडिशियल जजमेंट, डिग्री, डिटर्मिनेशन, सेंटेंस और ऑर्डर इश्यूड इन अ केस सिविल और क्रिमिनल बाई एनी कोर्ट और ट्रिब्यूनल except a military court or a court martial order. This petition is known as special petition leave. An interim or interlocutory order, decree or judgment can also be challenged. It need not to be final. Condition क्या है? तो it can only be exercised in case of substantial question of law or gross injustice. Time limit क्या है? तो it must be fulfilled within 90 days from the date of high court judgment or within 60 days against the order of the high court refusing to grant the certificate of fitness for appeal to the Supreme Court. यहाँ पे पिटिशन देख लेते हैं. 3 तरह का पिटिशन है. पर्पस क्या है? इन कॉन्स्टिट्यूशनल और इनोवेशन और फीचर्स इसका क्या है? तो स्पेशल लीव पिटिशन पर्पस इसका क्या है? टू अपील अगेंस्ट अ डिसीजन ऑफ एनी लोअर कोर्ट और ट्रिब्यूनल. कॉन्स्टिट्यूशन में देख लेते हैं इसका क्या है? तो अंडर आर्टिकल 136 ऑफ द कॉन्स्टिट्यूशन फीचर क्या है? तो इट इज़ नॉट एन अपील बाय राइट बट इट इज़ ग्रांटेड एज अ डिस्क्रिशन ऑफ द सुप्रीम कोर्ट. रिव्यू पिटिशन देख लेते हैं. तो पर्पस इसका फॉर करेक्टिंग एरर्स एंड एड्रेसिंग न्यू एविडेंस. कॉन्स्टिट्यूशन में देख लेते हैं. तो अंडर आर्टिकल 136 ऑफ द कॉन्स्टिट्यूशन द सुप्रीम कोर्ट हैज़ द पावर टू रिव्यू एनी ऑफ इट्स जजमेंट और ऑर्डर. फीचर क्या है? तो ए रिव्यू पिटिशन हैज़ टू बी फाइल्ड विद इन 30 days ऑफ द डेट ऑफ जजमेंट और ऑर्डर. अगला देख लेते हैं क्यूरेटिव पिटिशन ए लास्ट रिजॉर्ट रेमेडी. पर्पस टू सीक रिलीफ व्हेन देयर इज ए परसीव्ड वायलेंस ऑफ द प्रिंसिपल ऑफ नेचुरल जस्टिस. कॉन्स्टिट्यूशन में देख लेते हैं क्या है? तो इवॉल्व बाय द सुप्रीम कोर्ट ऑफ इंडिया इन रूपा अशोक हुर्रा वर्सेस अशोक हुर्रा एंड अदर केसेस 2002. फीचर में क्या है? तो ए क्यूरेटिव पिटिशन में बी फाइल्ड आफ्टर ए रिव्यू प्ली अगेंस्ट द फाइनल कन्विक्शन इज डिसमिस्ड एंड इट मस्ट बी rare rather than regular. रेट jurisdiction ऑफ हाई कोर्ट. तो रेट क्या है देख लेते हैं. आर्टिकल 32 right to constitutional remedy, and Article 226 provide remedy for the protection of the fundamental rights of a citizen by empowering the Supreme Court and High Court respectively to issue writ when a fundamental right of a citizen is violated. High courts have the right to issue writs within the territory of the concerned state and to any government authority or person outside their territorial jurisdiction if the whole or part of the case cause of action arises in their state of concern. High courts can issue writ not only for the enforcement of fundamental rights but also for non-fundamental rights. Legal rights क्या है तो where as the Supreme Court can issue writs only in case of violation of fundamental rights. The remedy provides under Article 226 of the Constitution is a discretionary remedy of the court and thereby cannot be claimed as a matter of rights. In case of enforcement of fundamental rights, the jurisdiction of the Supreme Court is original but not exclusive. It is concurrent with the jurisdiction of High Court under Article 226. टाइप्स ऑफ रेट यहाँ पे देख लेते हैं क्या है, 5 तरह का रेट्स है. पर्पस क्या है, इशू व्हेन होता है और फाइनल इफेक्ट इसका क्या होता है. तो पहला हैबियस कॉर्पस मीनिंग टू हैव अ बॉडी ऑफ. पर्पस इसका क्या है, टू प्रोटेक्ट एन इंडिविजुअल्स पर्सनैलिटी लिबर्टी. इशू व्हेन कब इशू हो जाता है तो ए पर्सन इज अनलॉफुली डिटेन्ड जब होता है. तो फाइनल इफेक्ट क्या है तो लीड्स टू द रिलीज ऑफ द डिटेनी इफ डिटेंशन इज फाउंड टू बी इलीगल. दूसरा रेट है मैंडेमस मीनिंग वी कमांड. पर्पस इसका क्या है, टू कंपेल ए पब्लिक अथॉरिटी और ऑफिसर टू परफॉर्म ए पब्लिक ड्यूटी. कब इशू किया जाता है तो ए पब्लिक ऑफिसर फेल टू परफॉर्म ए पब्लिक ड्यूटी. फाइनल इफेक्ट क्या है तो इंश्योर दैट गवर्नमेंटल एक्शंस आर इन अकॉर्डेंस विथ लीगल ऑब्लिगेशन. तीसरा है क्यू वारंटो मीनिंग बाई व्हाट अथॉरिटी. पर्पस इसका है टू इंक्वायर इनटू द लीगैलिटी ऑफ ए पर्सन होल्डिंग अ पब्लिक ऑफिस. कब इशू किया जाता है तो ए पर्सन इज होल्डिंग ऑफिस बट इज नॉट entitled to hold that office. Final effect क्या है तो determines if a person is qualified to hold that office. Prohibition कभी इसका पर्पस क्या है तो to prevent a law court, lower court, tribunal और authority from exceeding its jurisdiction. इसका कब इशू किया जाता है तो a lower court acts outside the scope of its legal authority. Final effect क्या है तो halts the proceeding of the lower court acting unwillingly. अगला है टेरिटोरी मीनिंग टू बी सर्टिफाइड और टू बी इन्फॉर्म्ड. ये पर्पस क्या है तो टू क्वेश द ऑर्डर डिसीजन और जजमेंट ऑफ लोअर कोर्ट, ट्रिब्यूनल और क्वासी जुडिशियल बॉडी. कब इशू किया जाता है तो ए डिसीजन इज ट्रेंड बाई लीगलिटी बाइसिस और लैक्स जुरिस्डिक्शन. फाइनल इफेक्ट क्या है तो अलाउज फॉर द रिव्यू ऑफ लोअर कोर्ट डिसीजन एंड देयर एन्यूलमेंट इफ अनलॉफुल. अगला है ऑल इंडिया जुडिशियल सर्विसेज. Addressing the Supreme Court Constitution Day celebration November 26, President called for an all India judicial service to recruit judges to help make the judiciary diverse. About all India judicial services, Article 312 of Constitution provide for the establishment of all India judicial services AIJS along the lines of central civil services. Under AIJS, the judges of lower judiciary will be recruited centrally and then assigned to states, just as the Union Public Service Commission conduct the central recruitment process and assign successfully candidates to cadres like the present All India Service and such as AIS and IPS. The AIJS will not include any post inferior to that of a district judge. A district judge defined in Article 236 can include a city civic court judge, additional district judge, joint district judge, assistant district judge, chief judge of a small case court, chief presiding magistrate, additional chief presiding magistrate, session judge, additional session judge and assistant session judge. प्रोसेस क्या है तो द 42nd कॉन्स्टिट्यूशनल अमेंडमेंट इन 1976 aimed amended Article 312 Clause 1 of Constitution and empowered the Parliament to make laws for the creation of one or more all India services. Accordingly, under Article 312 Clause 1 of Constitution, if a resolution supported by at least 2/3 of its members present and voting is passed by Rajya Sabha demanded to create a service in national interest, then the Parliament may create AJIS common to the Union and the states by simple majority, amending Article 233 and Article 234 and regulate the recruitment and service conduction of person appointed into any such services. Article 233 deals with the appointment of district judge in state. Article 234 for subordinate judge officers deal with the appointment of person other than district judge to the judicial services. Amendment of the Constitution under Article 368 is not required. Our next टॉपिक हेडिंग इज इंस्टीट्यूशन एंड बॉडीज. तो कौन कौन सा इंस्टीट्यूशन बॉडी है देख लेते. तो पहला है लॉ कमीशन ऑफ इंडिया. ऑब्जेक्टिव क्या है इसका? टू रिफॉर्म लॉज फॉर मैक्सिमाइजिंग जस्टिस in society and promoting good governance under the rule of law, to carry out research in the field of law. Function क्या है? The review aims to repeal absolute law, examine socio-economic legislation affecting the poor, and ensure the judicial administration is responsive to current demand. It also examines existing law in light of state policy directives and suggests improvement and reform. The review also focuses on promoting gender equality and proposing amendments. The review also aims to simplify central acts and remove anomalies. The review also examines the impact of globalization of food security and unemployment, and recommends measures to protect the interest of marginalized group. It is a non-statutory body constituted by Indian government. From the time to time, it works as an advisory body to the Ministry of Law and Justice and consists of Law Commission of India. क्या क्या है? तो पहला है a full time chairperson. दूसरा 4 full time member including member secretary. तीसरा है secretary Department of Legal Affairs as ex officio member. Fourth है secretary Legislative Department as ex officio member. Fifth है not more than 5 part time member. The current law commission, that is 22nd law commission, was appointed in 2020 for a period of 3 years, which is extended up to August 2024. Historical background क्या है? तो it was first established during the British Raj era in 1834 by the Charles Charter Act of 1833 and was chaired by Lord Macaulay. First independent law commission was created in 1955 for a period of 3 years and was headed by M.C. Stilward, also the first Attorney General of India. अगला सेंट्रल ब्यूरो ऑफ इन्वेस्टिगेशन CBI. Central Bureau of Investigation CBI is the premier non-statutory investigate agency of India established in 1963 on the recommendation of Santhanam Committee on Prevention of Corruption. It derives its power from Delhi Special Police Establishment. It provides assistance to the Central Vigilance Commission CVC and Lokpal. It is also the nodal police agency in India which coordinates investigation on behalf of Interpol member countries at international level. Control क्या है? तो it operates under the jurisdiction of Ministry of Personnel, Public Grievances and Pension, but for investigating offence under the Prevention of Corruption Act, it vests superintendence of the CVC to the CVC. Function क्या है? तो it was set up to investigate corruption in government department and public sector undertaking. However, over the years, its jurisdiction has expanded to cover a wide range of cases, including economic offence, cybercrime, organized crime, and special crimes. Director क्या है? तो he is responsible for the administration of CBI and is appointed by the center on the recommendation of a 3-member appointment committee. It comprises of the Supreme Court of the Prime Minister as the chairperson, the leader of opposition LOP in the Lok Sabha, and the Chief Justice of India or a Supreme Court judge nominated by him. If there is no recognized LOP, then the leader of the single largest party is included. The Supreme Court in 2019 mandated that no officer with less than 6-month tenure remaining can be considered for the post of CBI chief, and that the director will remain in office for not less than 2 years and can be transferred only with the consent of appointing committee. General consent क्या है? तो Section 6 of the Act makes it mandatory for the CBI to take prior approval from the concerned state government before proceeding with any investigation in that state. This consent can be either case specific or general and is given by the states to help the CBI conduct seamless investigation of corruption cases. When a state gives a general consent to the CBI for proving a case, the agency is not required to seek fresh permission every time it enters that state in connection with the investigation or for every case. In contrast, if the CBI does not have the general consent of a state government, it is required to apply for consent on a case by case basis and cannot act before the consent is given. सुप्रीम ऑडिट इंस्टीट्यूशन SAI कंटेस्ट क्या है तो सुप्रीम ऑडिट इंस्टीट्यूशन SAI 20 summit conducted in Goa under India's G20 presidency. It focused on collaborating on sharing the best practices, capacities building and development of appropriate auditing guidelines and accountable toolkits for auditing national priorities. टू priority एरिया कौन कौन सा था? पहला है ब्लू इकोनॉमी, focuses on conserving and using ocean, sea and marine resource for sustainable development. और दूसरा क्या है? रिस्पॉन्सिबल आर्टिफिशियल इंटेलिजेंस, इनेबल द डिटेक्शन ऑफ फ्रॉड, automates reductant auditing and identifies higher risk transition. About Supreme Audit Institution SAI, they are independent non-national level public oversight bodies which audit government revenue and expenditure. They provide an assurance that the resources are being used as prescribed by scrutinizing public finance, the management and submitting a report on the same. They derive their mandate from the Constitution or a legislation. Controller and Auditor General of the India's SAI function क्या है? To undertake financial audit of accounting proceeding, financial statements of an organization and compliance audits, review the legally to transition made by the audited body, conducting performance audit to scrutinize three E's: efficiency, effectiveness and economy of government undertaking. International Organization of Supreme Audit Institution INTOSAI. INTOSAI operates as an umbrella organization for the External Government Audit Committee. INTOSAI is an autonomous, independent and non-political organization. Nearly every SAI from an UN member country is a member of INTOSAI. INTOSAI has a number of bodies and organs, including committees and working group, which examine specific issues on relevance to SAIs, such as professional standard, environmental audit, and capacity building. INTOSAI services as a forum for SAI worldwide to exchange experience and work collectively to improve public sector accountability and transparency. National Commission for Scheduled Caste NCSC. NCSC is a constitutional body under the jurisdiction of Ministry of Social Justice and Empowerment, established to provide safeguard against the exploitation for scheduled caste and Anglo-Indian Committee to promote and protect their social, educational and economic and cultural interest. Article 338 contains provisions for NCSC, Article 338A for NCST and Article 338B for NCBC. By 89th Amendment Act 2003, the Article 338 या 338 was amended, introduced Article 338A, and the erstwhile National Commission for Scheduled SC and ST was replaced by two separate commissions, NCSC and NCST, from 2004. The 102nd Constitutional Amendment Act 2018 provides constitutional status, introduced Article 338B to National Commission for Backward Class NCBC. The first Commission for Scheduled Caste and Scheduled Tribes was set up in August 1978. It functions from its headquarters in Delhi and consists of a chairman, vice chairman and 3 other members. The central and state government are required to consult NCSC on all policy matters affecting the SC's duty and functions. The Commission investigates and monitors safeguards provided for scheduled caste under the Constitution, investigate complaints about deprivation of rights and practices in socio-economic development plan. It evaluates progress and presents reports to the President annually as needed. The Commission recommended measures for effective implementation of safeguard and other measures for the protection, welfare, and socio-economic development for scheduled caste. It also discharges other functions related to the protection, welfare, and development of scheduled caste as specified by the President or any law or rule made by Parliament. Similar functions are required for Anglo-Indian committees. पावर क्या है तो NCSC has the authority to regulate its own procedure and has all the power of the civil court when investigating matter or complaints. It can summon and enforce witnesses, require document discovery and production, revive evidence on affidavits, request public records, issue summons from witness examination, and investigate other matters determined by the President. डिजिटल पब्लिशर कंटेंट ग्रीवांसेस काउंसिल कंटेक्स्ट क्या है तो द डिजिटल पब्लिशर कंटेंट grievances council DPCGC recently recommended punitive action on an OTT platform invoking the Information Technology Rules 2021. About the Digital Publisher Content Grievances Council DPCGC, it is an independent self-regulatory body for online curated content OCC provider. It was set up under the aegis of Internet and Mobile Association of India IAMAI. DPCGC has been reconsidered and registered by the Ministry of Information and Broadcasting as Level 2 self-regulatory body for publisher of OCC provider under Information Technology, Intermediary Guidelines and Digital Media Ethics Code Rule 2021. The DPCGC has an online curated content publisher OCCP council composed of publisher of OCC as member and an independent grievances redressal board GRB consisting of a chairperson and 6 members. The GRB will be chaired by a retired Supreme Court High Court judge and the member will comprise eminent persons from the media and entertainment industry and experts from various fields including child rights, minority rights and media law. Function of GRB: it will oversee and ensure the alignment and adherence to the Code of Ethics by the OCCP council members, provided guidance to entitles on the Code of Ethics, address grievances that have not been resolved by the publisher within 15 days. Here grievances appeal filed for complaints. DPCGC through the GRB aim to usher in a redressal mechanism which will ensure a balance between addressing viewer complaints and showcasing contest in fresh speech environment without ad hoc intervention. अगला है इन्फोर्समेंट डायरेक्टरेट ED. तो आइए देख लेते हैं इसके बारे में, ED के बारे में भी. The Enforcement Directorate was established in the year 1956 as an enforcement unit under the Department of Economic Affairs. Later, in 1957, the unit was renamed as Enforcement Directorate. Administrative control क्या है तो presently it is under the administrative control of the Department of Revenue under the Ministry of Finance for operational purposes. Function क्या है तो ED is responsible for enforcement of Foreign Exchange Management Act 1999 FEMA and content provision under the PMLA. ED has the power to attach the asset of the culprit found guilty for the violation of FEMA. It has also been empowered to undertake search, seize, arrest, prosecution act and survey etc. against the offence committed under PMLA. Appointment of Directorate of ED. The ED Director is appointed by the central government of the recommendation of a committee chaired by Central Vigilance Commissioner and members comprising a Vigilance Commission, Home Secretary, DOPT and Revenue Secretary. Next is Commission for Scientific and Technology Terminology CSTT. तो इसे हम अगले वीडियो लेक्चर में करेंगे. इस वीडियो लेक्चर को यहीं पे समाप्त करते हैं. उम्मीद है कि आपको यह पसंद आ रहा होगा. तो कमेंट बॉक्स में जरूर बताएंगे आपको हमारी यह पहल कैसी लग रही है और वीडियो को ज़्यादा से ज़्यादा शेयर करें उन दोस्तों तक जो इस बार के UPSC एग्जाम प्रीलिम्स देने वाले, उन तक इसे जरूर पहुँचाएं और कमेंट में हमें जरूर बताएं. वीडियो को लाइक करें और अगर आप लोग चैनल पर नए हैं और अभी तक चैनल को सब्सक्राइब नहीं किया तो प्लीज़ इसे सब्सक्राइब करके हमें सपोर्ट करें. तो मिलते हैं आपसे अगले वीडियो लेक्चर में. तब तक के लिए जय हिंद, जय भारत.